Hello and welcome to the latest instalment with me, Linda Wright, the Planning Pundit, where I talk about day-to-day planning issues that have arisen either in my week. There tend to be fairly basic planning issues, but nonetheless very important. And I want to talk to people so that you can avoid pitfalls if you're a property developer or investor, so that you're advised in advance of these things happening, possibly because the reason that they come up in my week is because either a client has come to me to get them out of a problem, or there's an issue that's arisen that they want sorted out before it becomes a problem. So what are we going to talk about in episode 4? We're going to talk about conditions. Now, conditions, it's rare to find a planning application these days without conditions. However, there can be some approvals without conditions. It's rare. Councils' planning officers can either approve an application unconditionally, they can either approve it with conditions, or they can refuse it outright. Now, the reason that the conditions are put on there is that it makes an application that otherwise might have to be refused approvable. So there is a reason for the conditions. Now, I have seen some completely irrelevant conditions put on planning, some planning approvals, and that is because a lot of councils now use standard conditions. And unfortunately, these standard conditions are not a one-size-fits-all. So unfortunately, you'll read a decision notice and you'll think, well, that doesn't make sense. And it's because they've used, rather than writing them out, or typing them out, then they have used a standard condition and it doesn't really fit the project or the development that you're undertaking. So, planning conditions. There are 6 tests. These tests are laid out in the National Planning Policy Framework. And the tests for conditions are that they have to be necessary. They have to be necessary to be placed on there to make the development approvable and to make it acceptable in planning terms. Also, it has to be relevant to planning. It can't be whimsical and refer to other issues. Equally, it has to be relevant to the development being permitted. And then also it has to be enforceable, because if the council are going to put conditions on there that they have no hope or chance of monitoring and ensuring that the condition is being complied with, then it's not enforceable. So it wouldn't fit with that test. Conditions have to be precise. Now, I've seen some woolly conditions in my time, and one site that I was dealing with when I worked for a volume house builder had 119 conditions on. Now, it was a big site and it was a complicated project, but it seemed to me that that was ever so slightly over the top. And government guidance now is to advise councils that they should keep conditions to a minimum where possible and make them concise and precise. Final test is that they should be reasonable in all other respects. Now, again, some conditions are more reasonable than others. But generally, the conditions that are placed on a planning approval are there for a reason to make that development acceptable where it might not otherwise be. Now, if a council cannot put conditions on there, then they might have to resort to a Section 106 legal agreement. I'm not going to talk about Section 106 legal agreements here, but it will probably come up as one of these episodes during the rest of 2023. So we'll talk about that at a later date. But I'm talking about conditions today. So this is, I advise, it's important because I advise most of my clients when, unless I get an unconditional approval, when something is approved, you get the decision notice, you go, what? We got permission. And everybody scoots off down the road, opening the bottles of fizz or Prosecco, whichever you prefer. And they think, yes, we've got it, let's go. And everybody, it's all hands to the pumps, and everybody starts doing the conversion, the new build, whatever it is you've got approval for. You mustn't do that. You must step back, read the decision notice and see what it says and see what the conditions say. Now, some conditions will be what are called precedent conditions. That means that they need to be discharged and they need to be sorted out, basically, before work commences. Now, councils are supposed to advise either you or your agent or your architect of any precedent conditions, and they're supposed to agree them with you. Councils in 2023 are lacking in resources and they're quite stretched. So I'm finding that that is not really happening. It is with some councils, obviously, who've got, you know, more resources, more bums on seats, and they've got a slightly lesser workload. But it does depend on the workload as to whether or not you will be advised of these precedent conditions. For example, a precedent condition might be that there is possible land contamination and it has to be investigated if you are doing a new build. So that would have to have an expert consultant's report to assess any possible land contamination. So that then would be submitted to the council. Now, this is where this becomes difficult, because a lot of people, once they've got the planning permission, they're off down the road and they want to get on with it. However, conditions that need to be discharged and say that further information should be submitted, conditions have to be the subject of another planning application to discharge those conditions. So additional information, in the case of land contamination, additional information might need to be submitted, and it has to be signed off by the council. That condition has to be discharged by the council. So it is going to take you another several weeks or months, depending on workload. And if I'm perfectly honest, I'm ex-council. If I'm perfectly honest, the discharge of conditions drops to the bottom of the pile because you concentrate on full planning applications. So it might take more than a few weeks for you to get your conditions discharged. If you have submitted additional expert information that was required, or you've submitted a landscaping scheme or something, whatever is required by the particular condition, that has to be assessed by the council and found to be either acceptable or unacceptable. If it's acceptable, your condition is discharged. If it's not, then you have to submit additional information, or the application for the discharge of condition can be refused. So from that point of view, you need to make sure that these things, you build time in and these things get dealt with. There are a lot of things the precedent conditions you must get sorted out. If it's things like, I don't know, materials for a bin store or something, that's less important. However, I have to say this towards the end of this, you have to discharge conditions. If you do not discharge planning conditions, it can invalidate the entire project. It can invalidate the entire planning approval. Now, again, one of these things, I've put 2 discharge of conditions in recently. Again, a lot of people don't come back to me because they skip off down the road and they just ignore them. And a lot of people get away with it, to be honest, because again, there's not the resources to check on the conditions and see if they've been discharged. I've actually had 3 people come to me, one of which was more serious than the other 2. One has been approved, one has now been in for several months, and the condition has not been discharged, and it's a variation of a condition, because that's another thing that you can do. If you have a condition that doesn't suit, you can either appeal it entirely and ask for it to be removed, or you can submit another application. It just goes on for days, this. You can submit another application to actually vary that condition. For example, hours of opening, that kind of thing. So you can do that and have that varied. So conditions, they're not there at the whim of council planners. They need to be read. They're on your decision notice. They need to be read. They need to be taken and listed, which ones need to be discharged as precedent conditions before you start work on the property. There will also be potentially conditions on there, for example, laying out of car parking spaces, that would need to be discharged before a flat conversions were occupied. So you need to read each condition fairly carefully to see into which category it lies, because you're certainly going to have to discharge, bat surveys and things like this are going to have to be done before you start work on the site. So that's me. I hope that was helpful. Linda Wright, Planning Pundit. I hope that was helpful. Talking about planning conditions and how important they are, especially if you have got investors or if you've got lenders involved, because lenders quite recently have come along and said, well, have you discharged the conditions on the planning application? And they were about to refuse the lending. So, you might think, oh, it doesn't matter, I won't bother. But when you come to refinance or you come to sell, conveyancing solicitors might look at this again and say, well, there's no evidence of the discharge of conditions. So if that is the case, whilst it might not matter initially, certainly down the line from a financial point of view, it may come back and bite you. So that is planning conditions. That's me, Linda Wright, the Planning Pundit. Thank you very much for watching. If you are interested at all in planning, then please like, share and subscribe, so that me blathering on about things gets disseminated to people who might need this sort of stuff. Thank you for watching. I will see what topic comes up next week, and I will be sharing that with you again next week. Thank you again for watching, and I'll see you next time.